When you enter the United States on a K1 or Fiance visa, you are given 90 days to marry your U.S. citizen who sponsored you for the K1. This is a 90-day test case to determine if the two of you are compatible. Because this is a faster route through the K1, usually entry into the United States, than a green card would be based on marriage, the K1 comes with certain limitations. The main limitation for purposes of getting a green card is that you can only get a green card based on marriage to the U.S. citizen who sponsored you for the K1. You're not allowed to marry someone else instead or get sponsored by an employer or apply for a green card on a different basis and try to adjust your status or apply for a green card in the United States based on your K1 entry or when your last entry was on a K1. The limited exception to this is that if you were to remarry a U.S. citizen who happened to abuse you and you were eligible to file under the Violence Against Women Act to obtain your immigrant visa and green card based on that abusive relationship, because the statute has been amended to allow any means of entry to be able to adjust for a vow of self-petition. But always consult a licensed immigration attorney before taking this path. For anyone else, that means that if you do not merely marry a U.S. citizen who sponsored you, but you marry someone else who's a U.S. citizen, if you do not leave the United States within the 90 days, then you have to consular process. And if you remarry a different U.S. citizen, this means you have to leave the United States and interview at a consulate abroad for your green card. Depending on how long you've overstayed your 90 days granted on the K1, you could be triggering that 3 or 10-year bar of unlawful presence that can only be waived with a showing of extreme hardship to your U.S. citizen spouse or if you have a permanent resident spouse or parent. But this case is especially more difficult when someone has a K1 history because immigration could have the impression that you're marrying the second U.S. citizen just as a means to stay in the United States permanently. So you're going to have to explain in detail the sympathetic and hopefully understandable circumstances as to why you overstayed in the first place and why you did not marry the U.S. citizen who sponsored you for the initial K1. This will have an effect on the discretionary part of any kind of 3 or 10-year bar waiver. Further, if you were married right away or if you have not been married for a long time to the new or second U.S. citizen spouse, then the hardship argument could also be very difficult for you to make. So before you leave the country on a new relationship with a new U.S. citizen, always consult a licensed attorney to see what your options are. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.